Good evening, this is Laws 12062, Alternative Dispute Resolution. It's week 4. Tonight we're talking about mediation, and the specific emphasis is on mediation for the purpose of the first assessment piece. Just a few comments about the first assessment piece. In essence, what I would like you to do is come up with your own scenario, invite 2 people to assist you in the process, record the session as an audio-visual session, and provide the other participants, colleagues preferably, with some parameters as to what the nature of the dispute is, but make sure that there's some flexibility to allow them to play the roles in a certain way, and I expect that there will be some surprises as a result of what they say or what they do, and that's a good thing, because that will give me a better idea of how you can assess to assess your mediation abilities. So don't be concerned about surprises. Try and embrace that and welcome that in the process of the assessment piece. Now, ideally, if things are going to work the way I'd like, you'll actually upload a link to your audiovisual piece through Moodle. So in the way that you normally upload an assignment piece, maybe a Word document, just upload a Word document with a link to your assessment piece, and maybe just a very brief comment as to the nature of the dispute, or perhaps the type of mediation or conciliation that you chose to conduct. It may be apparent through the way in which you conduct the process, but it wouldn't hurt if you tell me, look, I'm doing this in a style of mediation, which is the classic style of mediation, or you may say, look, I've chosen to undertake this ADR as a conciliator, for example. So just give me an idea of that, upload it through Moodle in a Word document. That way I can see exactly when you've completed the assessment piece, and I can find your link immediately. If there are any problems with that, please let me know. All right, so mediations. There are a number of steps, as you would have seen in your reading, for the mediation process. The steps are pretty well established, and the first thing to do is, I suppose, set the scene. Make sure that the parties are comfortable, make sure that everyone understands the process, understands why you're there. So as part of your assessment, I'll be looking carefully at your body language, the use of your words, the way in which you address the participants, and even it might be things like the way you've organised the seating, the way in which the room is laid out. You know, there might be simple things like whether you've supplied some water for each of the participants, things to make them ready to go, maybe provided them with a notepad and pen. Those sorts of practical things might be useful, and I'll be looking out for all that. So I'd expect that you'll start your session by perhaps inviting the parties into the room, or if they are in the room, giving them some idea of what this process is all about. The mediation would start sort of per se with the opening comments made by the mediator. And you can read about those comments, but it's very important that you have a style which is structured that works for you. It may be that you write a script, it may be that you write some dot points or some enumerated points just as a guide. However, ask yourself this question: if you went into a mediation session and the person who was there to assist you and the other side in coming to an agreement was reading from a standard script, how do you think that would make you feel as a participant from the outset? Please feel free to jump in with a response or use the chat facility. So tell me what you think about a script, or a fully written script for the opening statement. Good or bad? Amateurish, says Tony. I agree with that. Yep. Not very good. Fake. Yeah. I don't think it's going to work, is it? So you need to convey a process which shows that you're in control, that you have authority, that you have experience. And it seems to me the best way to do that is to create some sort of flow chart for yourself, or list, or dot point, and then practice. Just practice your opening statement. Now, the opening statement probably would go for about 5 minutes, and it might be something like this. Good afternoon, my name is John Milburn. I'm a mediator appointed by the Queensland Civil and Administrative Tribunal, and I'm here to assist you in coming to a resolution of the dispute, which is now before the tribunal. I do thank you for attending. It's important that you participate in this process voluntarily. It is a process that provides you with an opportunity to resolve your dispute. My role is to assist you. I'm not here to make a decision. I'm not here as a judge or a jury. I am a lawyer, but I'm not here today in that capacity. I understand that neither of you have had contact with me in the past. You can be assured that my role here is neutral. I'm completely impartial. I have nothing to gain from what might be resolved in this dispute or this settlement. So my role is to simply assist the both of you in coming to a resolution, if at all possible. Now, I should indicate that while I'm saying this is a mediation session, it is in fact a conciliation. What that means is that it's a mediation with a little twist. It's a mediation with muscle, we might say. And that the twist comes in through the fact that as a member of the tribunal, I do have power to make orders. And if we don't resolve this matter today, then I can indicate to you that it's likely I will create some orders which are effectively directions as to the future conduct of the matter. However, my main focus will be helping you to come to a resolution of this dispute. That's why we're really here. The process may take 3 hours or so. I do hope that you've allocated that appropriate amount of time. Are there any issues in terms of the time? If so, please let me know now. All right, well, that's good. So let's progress. I take it also that you have the authority to settle the matter. It is important that you're here with a view to finally determining the matter. That means I need to be assured that you have the authority to settle the matter. That's correct? All right, that's great. My preference is to proceed fairly informally. I like to use first names. Does anyone have an objection to that? Great, please feel free to call me John. But I will ensure that I have your full names for our records. So if I could have your full names. Thank you, I've made a note of that. Okay, so as I mentioned before, I'm not here to judge the matter. It's important that you understand that my primary role is to assist you, hopefully, in coming to a resolution of the dispute. But you'll understand that we can't really effectively resolve a dispute unless we can identify the issues of concern. Now, it may be that there are certain issues that are of concern to one or either party, maybe both. But let's identify what those issues are and let's create an agenda so there's some structure to our discussions today. And the way in which this mediation process or conciliation conference process will work is that I'm going to invite both of you in turn to provide an opening statement, just a relatively short statement, and I'm very keen to hear from you as to what are the most important issues that need to be discussed today. So tell me in your own words, when we get to that stage, which will be shortly, why are you here? What are the issues of concern? And perhaps, what do you see as being an appropriate way to resolve this dispute? I'll hear from you both in turn. While we're doing that, I would ask that you please not interrupt each other. So, once we've heard from both parties, I'll try to assist you in determining the appropriate issues. We'll create an agenda and we'll work through that agenda. Once we've created the agenda, I'd like to open the discussion up so that we have a first opportunity, if you like, to resolve the matter. I appreciate that these issues are of great concern to you, and we will ensure that you have every opportunity to be heard and have your opportunity to resolve the dispute. Essentially what I'm saying is this is your dispute and I want you to take control and take ownership of it. Because if we don't resolve the matter today, then to some very considerable degree, I trust you understand that the dispute will be taken out of your hands and placed into the hands of someone, perhaps like me, a member who will make the ultimate decision for you. And you won't necessarily have any control over what ultimately happens if we don't settle it today. So today is your opportunity to take control, and I'd urge you to do that. So once we've had an initial discussion, it may well be that I break to go into private sessions with both of you. And in those private sessions, I'll be discussing matters on a without prejudice basis with each of you in turn. And essentially what I mean by that is that anything that you tell me during that private session will remain confidential. I'm not going to disclose it to the other side. It may be that during that session you make the decision that you will provide some further information or provide a further settlement, but I won't do that. So the idea of the private session is after we've had a chance to attempt a negotiation first up, we'll have those private sessions and then we'll return for a second attempt to resolve the issues of concern. Now, some ground rules. The proceedings today are confidential, they're without prejudice. What I mean by that is that I'm going to encourage you to make admissions, make settlement offers, identify all appropriate issues that need to be considered. And the whole purpose of that is to work towards a resolution, to work towards a settlement. You can't really do that unless you're prepared to talk in a very meaningful way with each other. So the protection is that if you make some offers, if you make some admissions, if you make some compromises, please remember that that will remain within this context, and those admissions, those offers, those compromises that you mentioned today cannot be used in later proceedings by the other side if we don't settle today. So you understand that essentially, if you make an offer, it stays in this room, it stays here today. It's not going to be considered at the ultimate hearing. You know, the thing about mediations or conferences is that we have a real opportunity to explore all the issues and all the alternatives. It's not just going to be a matter of necessarily saying it must be this resolution or this solution or that. We can think of all sorts of solutions, and I'll probably at some stage encourage you to do that. It might be some sort of brainstorming exercise where we try to identify all the possible solutions to the issues of concern today. I understand these are confidential proceedings today. I hope you can understand that that is the case. I do appreciate that these are emotional issues, and we expect that. So I ask you to respectfully address each other. I will encourage you, for the most part, to address each other, and I understand that this is emotional, and we'll move on from there. Look, ultimately, it may be that if we do resolve the matters, you walk away both a little disappointed, and that might be okay, because ultimately, even if you walk away a little disappointed, in the long run, it may work to your advantage to do so. So I'd encourage you to be open-minded about the discussions. All right, so process is confidential. Are there any questions? Does anyone have any issues they wish to raise before we start? All right, great. Now, Mr. Smith, this is your application. I'd like to hear from you first up. Okay, that was a bit long and a bit rambling, but that was kind of an off-the-cuff opening statement. Are there any questions as a result of what I just did then? All right, so you probably saw...
Yes, I have a question.
What was that, sorry?
I have a question.
Yes.
You were saying something about it's a conciliation. No, that's right. You were saying you are a conciliator, and you then have the power to make a decision to enforce it with those people. In an introduction by us, we don't at this stage. So should we be saying that, or just sticking with who we are, law students?
No, that's fine. This is a role-playing exercise. So for the purpose of the exercise, you are, for all intents and purposes, an expert in the field, and you are conducting a real but mock mediation or conciliation. Now, we're dealing with conciliations next week. So there is that subtle difference between mediation and conciliation. They look the same, but the difference is that in a mediation, a pure model of mediation, the mediator is there to encourage the parties to come to a resolution and will not particularly intervene in the process by providing some degree of feedback beyond general reality testing, in other words, specialist feedback, and will not make any orders. And I just need to explain those two concepts. So thanks, Sarah. It's a really good question. The first thing is, when I talk about a conciliator providing some feedback beyond reality testing, what I mean is that in my context, what I just did then, I'm saying, well, look, I'm a member of QCAT. I'm here today to help you to resolve it. But because I'm a member, I can provide you with some feedback as to what you might expect if the matter doesn't resolve today. And at that stage, I will then go on and say at some length, but just because I think that might be the resolution ultimately, that doesn't mean that another person down the track will have that view. And the other issue is, in terms of the ability to make orders or directions, I did say I'm not here to hear the matter or determine the matter, and that remains the case in a conciliation. But in the conciliation, there is the power for the conciliator to make some orders or directions. And that might be to say, all right, well, we haven't resolved it today, but you are required to file affidavit material by a certain date, etc., etc. So they're kind of directions as to the outcome. So when you do your session, I'm happy for you to choose to act as a mediator or a conciliator. You can choose. We'll talk more about that conciliation process. I've just embarked on a quick summary of it tonight, and I don't mind, but it's a role-playing exercise for the participants and a role-playing exercise for you as well to some degree. It's a very long answer to your question, Sarah. Did that make sense? Is that okay? All right, thanks, Sarah. All right, are there any questions? Audrey says, would you explain the without prejudice matter a little more in that introduction stage? Yes, I think it really is important that you emphasise that the process is confidential and that people should be free and confident of making offers or compromises in the knowledge that it remains confidential. Can't be used in later processes and can't be used beyond the immediate process. So I hope that answers your question, Audrey. Are there any other questions, any other feedback in terms of what we just did?
John, in Spencer's book, in the appendices at the back of the book, there are quite a few very useful documents, but most of them seem to relate to the New South Wales Law Society. Now, does Queensland have something equivalent, or should we go by those New South Wales Law Society proclamations?
Thanks, John. Yes, the text is heavily focused on New South Wales law. Queensland does have something similar, and I don't mind for the purpose of the assessment if you use what's in the text. That's perfectly acceptable. It may be that I can access some further material which is more specifically related to Queensland, or you may be able to find something. And if we do find something, let's share it through you, crew. So I hope that answers your question, John.
Yes, thank you.
Thank you. All right, any other feedback or questions? You can come in live, thanks for those who have, or you can use the chat facility. Okay. All right, so once you've set the scene, once you've had the parties settle into the process and you've given your opening statement, what we're then looking for you to do is transition into this stage where the parties give their opening statement. And I just started to do that at the end of what I said before. So when the parties give their opening statement, can you just give me some idea of what you might expect from the parties? Bearing in mind that they may have some agendas or emotional issues. So come in with the chat facility. What are the things that might go wrong when you start to ask for people? People might be hesitant at first, angry. Yes? Yep. So they might be hesitant, they may not talk, or they might be angry. All right, so how are we going to deal with those sorts of issues? It might be emotional, says Brad. Yep, I agree with that. So might let the other party speak. There might be interruptions. Okay, so how do we deal with those sorts of issues? It may be that we try to establish our authority. Gentle but firm reminder, says Sarah. I like that. So you are there to help the parties, but remember at all times you're in charge and you need to have that authority, but do it gently. There's no point shouting at people and you'll lose it if you do that. Break down the barriers, says John. I like that. So just try and break down the barriers. Maybe make sure, of course, that they understand that they're not allowed to interrupt. That's one of the ground rules. Make that clear and remind them of that ground rule if they should do that. Find some common ground early, says Brad, and I like that as well. Maybe you can ask some exploratory questions. Maybe at that stage you use your reframing techniques to reframe what is being said and take the emotion and the anger out of it, strip that out of it so it comes back to the issues. So what we're looking to do then at that stage is summarise perhaps what's been said, maybe do a little bit of reality checking to see if they've covered everything that is there, and ultimately what we need to do during those opening statements is translate what is being said into a list of issues/agenda. Now that's a really tricky part because you've given your opening statement, you've now asked the parties to give their statements, and while you're trying to identify what the issues are, while you're trying to identify the agenda, you're having to deal with these issues of emotion and anger, etc. You've got to remain in control, but you've got to keep moving forward with the process. You need to be friendly, open with your body language, calm and in control during that process. And there is a bit of an art, and I think I mentioned this last week, that as you hear something which is critically important, you think, that might be a very good agenda item, you need to learn to be able to write that down without diverting your eyes away from the parties. So you might just find that it's 5 or 6 words written down on the sheet once you've completed the process of hearing the opening statements, and that might then form your agenda. Okay? Now, there's nothing that says you must maintain eye contact with the parties at all times. But you know, when we talked about it being perhaps amateurish, if you just read off your script in the opening statement, it might be a bit amateurish if you stop eye contact to write notes while they're giving their opening statements. So there's a little bit of a compromise that must happen there. So John says, does the mediator get to see the opening statements before they're given? No, generally not. The opening statements by the parties, at least in the model that I'm promoting, is given live, and that's the first time in a real context generally that the mediator would see them. Now, in some more formal mediation processes, there are documents which are provided to the mediator, one in advance, but that's not the sort of mediation that I'm looking for on this occasion. I'm looking for something where the parties are delivering the information, as it were, the first time that the mediator hears it. That won't actually be the case because the mediator is the one coming up with the scenario. But there might be, and I expect there will be information which is thrown in by the parties as part of their role playing, just to ensure that the mediator is doing his or her job. All right, so do we have an understanding then of what happens when the parties give their opening statements and what you were expected to do and what you're trying to do in your role as the mediator or the conciliator? Once the parties have given their opening statements, you then try to create the agenda, and that's going to be issue-based. We're not really looking for an agenda that's positional-based. It may be that there's 1 or 2 things that are common, but we're really trying to identify the main issues of concern. And there might be an art here, there might be a difficulty in that you may have to ensure that one party is prepared to talk about an issue which is clearly of high relevance to the other party. So sometimes you get stuck where you've got issues that concern one side, not the other, and part of your skill is to, if you like, convert that individual agenda item into a joint agenda item. All right, then we go into the open session. And what we're looking to do in that first open session, where the parties are starting to talk to each other, is exactly that. Try to avoid them talking to you. As much as possible, have the parties talk to each other. Remind them that this is their dispute. It's their opportunity to identify the issues and talk to each other. So you may need to do that. You will certainly need to control the process, and you'll need to do lots of listening, acknowledging, reframing, summarising. All those sorts of things will come into it at that first stage. And the best way to do that, if you're having to intervene in the process, is ask open questions. You're looking to obtain information, sure, and that's important in terms of identifying the party's position or the issues for the parties. So obtaining data is important, but do try to do that in the context of open questions. I think we talked about open questions and closed questions last week or the week before. Everyone's up on what we mean by an open question or a closed question? All right. So we have this sort of process of open questions to draw people out. We're reframing, we're summarising, we're using all our skills, and we're trying to encourage the parties to work towards an agreement. Now, a word of warning, don't be too quick to encourage the parties to start exchanging offers from the outset, because you may have a quick blow up. If people start to make offers during that emotional stage, there is too much of a tendency for parties to say, you've always been unreasonable, you're being unreasonable, there's no point talking to you, and then you get a walkout. So try to avoid specific negotiation settlements in those early emotional stages. What you're looking to do is draw out the appropriate information, find out what the issues really are, and try to come up with some facts and some data that can be used by the parties then in the process of trying to settle. Now, after you've had this first session where people are talking essentially to each other, it's very likely that you'll have a separate session. I expect that you'll probably do that in your assessment piece. And if you're going to meet with one party, you should ensure that you do meet with the other side. Try, if possible, to give them the same amount of time, and remind them before you go into those private sessions that anything that they say to you during the private session remains confidential between that person and you, and you're not going to move on. A walker is, yes, John says a walker presumably means someone who leaves the session. Yes, a walkout is someone who just wants to get up and go, and that's not good. So you'll need to think about some strategies for that possible scenario. All right, so in the private sessions, you're doing a bit of reality testing. If a party is perhaps being a little unreasonable and a little stubborn, during that private session, it might give you an opportunity to talk about the what-ifs and how do you think that would work in practice. Practice using open-ended sorts of questions. It's not a matter of telling them what's going to happen necessarily at that stage, but try and get them to come to their own conclusions if possible. Once you've had your separate meetings, you would then go back into another joint session. It may be that during the private sessions, a person has said to you, look, I'm prepared to do this. My personal view, and then they might say, well, can you check the other side, see if they're willing to do that, or can you pass on that offer to the other side? My personal view is not to do that, but rather encourage the parties to make their own offers during the open session once we resume. That's my preference, and that's why I think we should be doing it. All right, so when we go back into the open session again, you're looking to encourage the parties to exchange some offers by this stage and hopefully resolve the matter. If the matter does resolve, then there's the question of how to document that agreement. You might have to give some thought to that whether you'll invite the parties to do the documentation, whether you'll do that, whether you have third parties involved like lawyers, etc. All right, now, are there any questions? Please feel free to come in live or to ask through the chat facility. Remember, of course, that during that whole process, you're exercising some of your skills, some of the things we talked about last week. It may be that you use silence as a technique, reframing, paraphrasing, summarising, some reality testing. Reality testing is really asking people to consider what are the likely consequences if they pursue a certain course of action. Is that really going to work? Is that appropriate? So if your dispute is about children, a dispute between parents, one of them says, look, this is what I propose, and it really doesn't ring true. Maybe just workshop through what will happen in practical terms. How is that really going to work? During the whole process, you need to be careful about power imbalances. It may be that one party is trying to dominate the proceedings over the other. You've got to try to bring that back. But it's a subtle art, because you can't be seen as dictating the process. You can't be seen as trying to take over the process. It's got to be their process, but you've got to allow people an equal opportunity, and you've got to try and provide them with an equal balance and attention. Okay, so what are the attributes that you need to achieve? And this will be our final topic for tonight. What are some of the attributes, personal qualities that you think you should be training yourself to achieve during the course of your assessment piece? Can I have some words, thanks?
I was thinking active listening.
Active listening, absolutely, yes. Thanks, Anthea. All right, so what about confident would be another word? All right, any other words? Calm, perhaps? Tone, patient, thank you. The tone is very important. Being patient is important as well. Try to encourage the parties and don't move in too quickly. Keep the process moving. You can get easily bogged down in this, but you've got to keep moving. Be prepared to think and be enthusiastic. I like that, Tony. Thank you. Be prepared to think of different ways to resolve this, a little bit like a light-footed title fight boxer. You've got to be light on your feet. Be prepared to move around. It may be that you say, well, look, let's not worry about that issue for the moment. Let's talk about another issue, and we'll come back to that issue. Be positive. Yes, I like that. Think about ways that you can encourage the parties to come to a common agreement about something. This was raised before, and if you get 3 or 4 points of common agreement, then you might be able to come back and parties will see each other in a different light because they've started to agree on things. Or be even-tempered. I like that as well. So if you really get stuck and there's an impasse and people just don't want to seem to move at all, how are you going to try to encourage them that in fact there are some things that they might agree upon? All right, so it's all very well to say, we'll get the parties to start agreeing on something, but what are some of the things that you might suggest to the parties that they already do agree on certain things? So suggest things. Be careful about suggesting things though. In a pure mediation session, it's supposed to be non-interventionist, but yes, and suggesting things can be done in the context of reality testing. Brad says, you both agree that you don't want to go to court. That's a good way to do it. Right, you don't want to go to court, you don't want to go to court. Right, we're agreed on that. You both agreed, says Brad, on wanting to resolve the matter. Get some consensus. Yes, we both want to resolve the matter. Well, let's agree that it's in everyone's best interest to reach an agreement today, says Audrey. That's a great way of framing it. That's very good. So you're starting to get people nodding to say, yes, I agree with him. You want to maintain a relationship, says John. I like that one. It may be very important. It might be a business relationship. It might be a relationship in caring for children. It might be a relationship as neighbours or workmates or whatever it might be. So talk about maintaining the importance of that relationship is a very good way to go. Okay, so but you need to think about those things and maybe have them in your toolkit ready to bring out should the need arise. And when you're on the spot, when you're actually in the mediation, what I'm hearing is that both of you want to blah, 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 says Brad. Yep, that's it. I like that. I like that phrase. What I'm hearing is that you, so that's a good way of framing. So you need to have some points written out. You need to have some questions ready to go to deal with certain circumstances, such as the impasse. Have some phrases ready to go. And I'm not suggesting that you read from that during the mediation, but you need to have them ready and you need to practice them. Okay. So tonight it's really just giving you some encouragement to get your notes together, get your toolkit ready to go, as it were, and then do some practice. All right. Before we wrap up, are there any questions?
John, one thing that Spencer mentions quite frequently is the costs involved. Can you give us any idea what sort of costs would be involved in a fairly straightforward mediation?
Yes. If the mediation is conducted through a neighbourhood or community mediation centre, probably fairly minimal, $50 or so, to be shared between the parties perhaps. If the dispute is a family law dispute involving children, or perhaps a better example might be a commercial dispute where both sides are represented by lawyers and perhaps a senior barrister who comes in as the mediator, then of course you're looking at potentially, even to the mediation stage, $10,000 or so. Which is nothing compared to the ultimate cost of the overall litigation. And 10,000 might be conservative as well. So pretty substantial sums. Thank you, John. Any other questions or comments before we wrap up?
I got a question, and I don't know if this is a silly question, but I'm still trying to understand the assessment piece. Who's actually doing the talking? Is it the other two participants, they're doing the talking and you're identifying the issues, and you're just mediating the whole process? I'm still trying to get my head around that.
No, that's great. That's not a silly question at all, Anthea. I'm really pleased you asked that question. So in the mediation model that I will be assessing you on, you will be the mediator or the conciliator, and you'll be doing some talking, but the other parties will be doing a lot of talking. And if things go well, you might actually find that you're doing a lot of nodding and making notes and making comments and bringing them back, but the parties might be doing most of the talking. So it's possible that you don't do all that much talking and you get a very good grade. So I hope that answers the question. But your job is to be the mediator. So you're in charge, so you'll set the scene, you'll be in charge, you'll get the parties together, you will make your opening statement, a bit like what I did tonight, and then you'll be encouraging the parties to talk. Silence could be golden. Yes, Brad, I agree with that. Anthea, does that answer your question?
Yeah, I got a bit of a problem because mediation, I can make it really easy, or I can make it a bit difficult, make it a little bit interesting. I got a family, custody of children issues that I selected. And it's normally when two people that go to a mediation, they're really emotional and angry with each other. And some couples are really get along kind of well, and they'll mediate in a nice way. And it's it depends which angle you go at it. And it's I can make it really easy for myself, or I can make it difficult. And like I said, who does the talking? Is it me or is it them?
I think in this context, part of the reason that I'm very keen for people to have colleagues that participate is that colleagues will be able to learn from each other and also understand that in order for this to work, there needs to be some issues in dispute, and there needs to be the opportunity for the mediator to show his or her skills. So I think that your colleagues are going to make sure that it's not too easy for you. Having done this in a similar sort of way, people were, perhaps if anything, went the other way and made life very difficult at times. And that's fine. If that happens, don't think, oh, they're being mean. Just think, oh, they're really helping me here because they're giving me a chance to showcase my work. I hope that answers your question, Anthea. But if it's really simple and you get two parties that come in and say, well, actually, we had a chat outside and we've come to an agreement and this is what we think should happen, well, it's pretty hard for me to make the assessment as to your abilities to mediate. So I'm sure that won't happen. Does that give
yeah, that answers my question. I just got another question. I'm supposed to pick 10 core issues. Can I actually come up with 10 issues, or do you just pick 5, or it just really depends on what you think is suitable to your thing? Hang on.
I would have thought in a usual mediation, there might be 4 or so issues of real concern. It would be rare that you'd have 10. That's a lot to work through in an agenda. But if you have 2 or 3 or 4 or 5 issues or agenda items, then that's fine.
Okay, thanks for that. That's all my questions.
Thanks, Anthea. Are there any other questions? I'm really keen to ensure that everybody has a good understanding of the assessment piece and the mediation process after tonight.
Yeah, I've got a question, John.
Yes, Tony.
You know how it says in the textbook and that, you know, if you're all in the same room, you use a whiteboard or something like that and put up the issues on what? Is it okay using the Zoom to use the share screen to use that as a whiteboard?
Yeah, absolutely. You can do that, or you can physically have a whiteboard behind you, and as even if the people aren't in the same room, you can have the whiteboard and you know, have the camera with that in shot. But screen share is fine. That's great. Be very happy with that.
Yeah, no. Okay, thank you.
Thank you, Tony.
Can I just ask you, if you have your group of 3 already, it seems like you have to do a sort of bit of encouraging along the way, because trying to get the people to cooperate and actually start seems to be a real issue. Do you have any suggestions there?
Well, I would probably work backwards. I say this a lot when I'm practicing law or studying law. Work back and try and obtain, firstly, a timetable. And it may be that you can say to your teammates, look, here is my draft conflict. And it might be like an A4 page of notes saying, here are the parameters of the conflict. And here's the timetable that I have in mind for my mediation piece. So you can say, I'm available on these days to conduct my mediation session. You know, which ones are available? Okay, that's the date. Let's lock that in. So I'll be doing my mediation on that day. It might be a week or 2 before the assessment is due, just to allow some, you know, what-if problems. And then just maybe schedule in a time when you can say, how I would like to just to discuss it generally in character, or just discuss the characters at a certain time beforehand. So I think that might be the appropriate aim. Take control of your own process. That way, if you've set out the parameters of the dispute and you've set the timetable and the time for it to happen, if things go astray and people just won't assist in the way that you want, then you can always ask someone else to come in. And I'm sure that in the last 2 weeks, there'll be a lot of requests generally through you crew saying, hey, I need someone to come in and help me. And I think a lot of people will be willing to come in and say, look, I'm not part of your group, but sure, I'll come in and play that character. And if they don't know much about the character, that's a good thing, because then they'll just play it the way they see it. So I hope that provides you with some idea, Erin, some structure. Okay. But that's a great question.
Yes, thank you. Thank you for that.
Thanks, Erin. Are there any other questions, any comments?
Yeah, quick question.
Yes, Erin.
Just as part of the process, if we do sort of two characterisations, would we give sort of both of those characters to each of our teammates so they know who they're in the mediation with, or just tell one person who they're going to be and tell the other person who they're going to be and let them find out on the day?
I think it would be, you can do it either way, it's a short answer. I think it would be interesting if you didn't, if you told one person that their character is to be played in a certain way and then kept it as a surprise for the other. But either way, and I think, as I said, I think people will come forward and they'll understand what you're trying to achieve or need to achieve, and they'll assist you in that regard. So I'm sorry I'm not giving you a definite answer on that one, Sarah. It can go either way.
No problem, thank you.
Okay, I really like these questions. Thank you very much. Anything further?
Excuse me, John, I have one.
Yes, Brad?
With the reality checking, do you do that when you have the parties in a separate meeting room or when they've come back in together?
That's a
joint meeting.
That's a really good question. It's possible to do it in both situations, but you've got to be very careful about reality testing in the joint session, because it may seem that you're biased or overly critical of that party. So the reality testing needs to be mindful of your role as being unbiased and impartial, and sometimes it works a little better if the reality testing is done in earnest in the private session, so that that party doesn't feel that you're biased with the other party in the room. But look, you won't get marked down if you do some reality testing in a joint session. And very often that's important, and very often that will work very well. But that's a great question. Thank you, Brad.
Thank you. Let's have one more, if you don't mind.
No, that's fine.
With the settlement agreement, and the parties agreed to have it structured as a contract rather than a deed, then there needs to be consideration. I think it was the textbook that mentioned that a small amount is paid. Who determines, what's a reasonable consideration? I mean, is it the peppercorn consideration, or is there some reasonable amount to show the good faith?
Yeah, so of course you're right. In contract, there does need to be consideration. That consideration can be a relatively modest amount. You don't need to worry about consideration if the agreement is in the form of a deed. But your scenario might be in the context of a mediation of a matter which is already before the court. So another way of resolving it might be through a consent order. The agreement is to be presented and a request made for it to be made an order of the court or the tribunal. So that's another way of doing it as well. But that's a great question. Thank you, Brad.
John, can I just ask another question as well, please? If you have a mediation session and the parties come to some sort of consensus and that is written up in a document form, that then goes to a court, does it, to be sanctioned by the court? And if so, does that document form a contract that can be held, I guess in law, that if somebody breaks or is in breach of that contract, can they be sued?
Yeah, no, that's a great question. Certainly the matter can be presented to the court or the tribunal with a request that it be made into a consent order. Sometimes there are issues where the court or the tribunal says, no, I don't think that's an appropriate order and I'm not prepared to make that a consent order. So you need to be careful of that. It may be that it is simply a contract which is enforceable. And when coming back to the question of consideration, remember, of course, that consideration is not just necessarily something which is providing a benefit to the other party, it may be that it's depriving a party of a benefit. So the consideration might be, in consideration of me not proceeding further with this litigation, the parties agree that this is the amount to be paid. So that can, and specifically say that it is enforceable if the matter is not complied with or the agreement is not fulfilled. So John says, is stamp duty to be calculated? Yes, stamp duty may well come into it, and that could be an issue as well. So thank you, John, for that point. GST may be an issue as well. Isn't a deed of confidentiality, says Audrey? Yeah, it may be that the deed does provide, or the agreement does provide, that the settlement is confidential and cannot be disclosed more generally. But the rule about confidentiality within the context of the mediation or the conciliation conference does have an exception, and that is if the parties come to an agreement, it may be that that agreement can be released or disclosed for the purpose of enforcement. So thank you very much for that question, Erin. I hope that has provided an answer. Are there any other questions?
I just got one more, which is, can you do private sessions in a family dispute mediation? Is that a wise thing to do?
Yeah, absolutely. You can do private sessions in a family law dispute resolution. And for the purpose of the assessment, I expect you probably will have a private session at some stage, just to show me how you go about the process. But yeah, that can be done. Thank you.
Thanks for that.
I really appreciate these questions tonight. It's been excellent.
Can I ask another one?
Yeah, absolutely. Thanks, Tony.
Do we have to, in this assignment, do we have to come to an agreement at the end, like at the 40 minutes, or?
No, that's a really good one. I actually like the ones where they don't necessarily come to an agreement, because that gives me an opportunity to see another skill that you might demonstrate. And that is the way you wrap it up. One thing that you try to do in those circumstances is come back to the points where they are in agreement and maybe see if they can come to an agreement about the future conduct of their litigation. So it may be that if your dispute is in relation to a matter of money for failure to repair an item or something, then you might say, well, look, just so that for both of you to benefit in the future litigation, what if you come to an agreement that these are the two issues that need to be considered by the tribunal, and these are the legal questions that you'd like to ask the tribunal or the court to consider? You know, that might form the basis of an agreement. Even though it's not a final settlement, you're still asking the parties to work towards some sort of an agreement. So, no, to answer your question, Anthony, if it doesn't settle, that's fine. You won't necessarily get a mark down. You might even get an extra mark. Thank you, Audrey. All the best. All right. So
yeah, no worries. Thanks.
Thank you. All right. Well, look, it probably is time for me to wrap up the session, unless there are any final questions. And please do continue the discussion through UCrew. All right.
Just one final logistical thing. Private sessions, if we're going through Zoom, didn't you say you wanted the whole Zoom thing in one go without editing?
I did. Look, for the purpose of this scenario, what you might do is, the other party is not supposed to hear the private session, but they might. I mean, that doesn't matter.
Yeah. Okay. No problem.
But we'll just do pretends.
Yeah. Cool.
All right. Okay. Well, thank you very much, everyone. I'll call it off for now, and we look forward to seeing you. And please continue discussion through UCrew, and we'll speak to you next week. All the best. Bye then.